All right, let's have a seat. Good afternoon to you all. Madam Foreperson, has the jury reached a verdict in this case?
No, Your Honor.
Do you feel like that it is likely that the jury on continued deliberations will reach a verdict?
No, sir.
Let me ask you this. Has the jury considered the highest level of the offense?
Yes, sir.
Is there a disagreement as to the highest level of offense?
Yes.
That's where your disagreement falls?
No, I'm sorry. It is not. That is not the case for the highest offense.
Okay. Does the jury agree on the highest level of offense, that the defendant is either guilty or not guilty?
Yes.
What is the verdict in that?
Not guilty.
Okay. So the jury has found the defendant not guilty of first-degree murder.
Hold on. This is a huge moment. The jury has unanimously cleared the defendant of first-degree murder, the most serious charge on the table. That means whatever disagreements remain, jurors have already agreed the prosecution did not prove the highest level of criminal intent beyond a reasonable doubt. Did you expect the case to turn this way?
Yes.
Okay. May I borrow the charge book for a minute so I can look at the verdict form? If you need it back to look at it, just tell me. Has the jury considered the second level of the offense attempted first-degree premeditated murder?
We did consider that.
Is there an agreement that the defendant is not guilty as to that offense?
Yes, sir. There is an agreement.
Has the jury considered the level of offense second-degree murder?
Yes, sir.
Is there an agreement that the defendant is not guilty as to second-degree murder?
Not guilty.
I have not asked you specifically, but are all of these agreements unanimous as to these levels of charges?
Yes, Your Honor.
Okay.
You have one shaking his head.
Beg your pardon?
You have one shaking his head.
I'm sorry. My question, and I'll come back in. My question was, is it unanimous that the defendant is not guilty of second-degree murder? And I'm going, since there was it's my question. Is there an agreement on that level of charge?
Agreement with who?
Nine.
Oh, I'd say not guilty on that one.
Sir, ma'am? Not guilty as to second-degree murder. Is that correct?
Correct.
Listen to what's happening here. The judge is carefully walking through each charge level by level, making sure the record is crystal clear. In criminal trials, precision matters. One misunderstood answer can create major appellate issues later. So this detailed questioning isn't just procedure. It's protection for the integrity of the verdict.
Okay. That cleared that up, General?
Yes.
Has the jury considered the next level of charge, attempted second-degree murder?
Yes, sir.
Do you all find the defendant not guilty of attempted second-degree murder?
Yes, sir.
Each of you? Ma'am? Okay, I'm looking at you because I want to see, and if you disagree, just let me know, okay? Now let's go back. We did not do this as a first-degree murder charge that I'm told you found him not guilty of. Is that correct?
And here's where the drama really crystallizes. The jury has worked its way through multiple homicide charges and reached agreement on all of them, except voluntary manslaughter. That means the entire case now hinges on a single remaining question. After hours of deliberation, this is the line the jurors simply cannot cross together.
Okay, I see head nodding affirmatively, and attempted first-degree murder. Is that correct as well? Okay. Has the jury considered the charge of voluntary manslaughter?
Yes, sir.
Is there an agreement, or has the jury found the defendant not guilty of voluntary manslaughter?
There was no agreement.
No agreement? Is that the level of the offense at which there is disagreement?
Yes, sir.
Is that correct, ma'am? All right.
When every juror indicates that further deliberations won't help, the court starts considering what's known as a hung jury. Judges generally prefer juries to reach a final verdict, but they also can't force agreement where none exists. At this point, a mistrial is becoming increasingly likely.
Would the state like the jury polled as to the first four level of charges?
No, Your Honor.
Or as to the level on which there's a disagreement? I think since we don't have a verdict, there's no reason to poll the jury as to that level. You agree, Mr. Taylor? I'm going to ask each of you this question. You just tell me, would further deliberations be of any value?
No, sir.
There it is, the split outcome. Not guilty findings on the higher charges, but a mistrial on voluntary manslaughter because the jury is deadlocked. Legally, that's a very important distinction. A mistrial is not an acquittal. The unresolved charge can potentially be brought back in court later. What do you think prosecutors should do next?
Do you all believe that the jury is hopelessly deadlocked with respect to the charge of voluntary manslaughter? I see everybody nodding their head yes. The court will enter a verdict of not guilty as to the charge of first-degree murder. The court will enter the charge of not guilty as to attempted first-degree premeditated murder. The court will also enter a not guilty verdict with respect to second-degree murder. And the court will also enter a not guilty verdict with respect to attempted second-degree murder. The court believes that the jury is hopelessly deadlocked with respect to the next level of charge, that is voluntary manslaughter. Is there any reason that the court should not declare mistrial at this time, General?
No, Your Honor.
Mr. Taylor?
No, Your Honor.
Court will enter and declare mistrial with respect to the charge of voluntary manslaughter. I want to say something to you. The jury, having completed the work as required by law and by this court, is discharged and excused with the sincere gratitude of the court. Judge Parham and Mrs. McMahon have asked me to tell you that you are excused from further service in this term. You do not have to report in August. You've done more than a share. I understand the personal sacrifices that each of you have made to be here every day on time, and specifically the sacrifices over the 11 hours plus in 2 days that you have spent attempting to reach a decision in this case. I thank you for your work, for your time, for your dedication to this case, because that is dedication to our system. That's dedication to our jury system and our effort to provide a fair trial for anyone who's accused of a criminal offense. Don't be frustrated or discouraged because you weren't able to resolve the case fully. It happens. You did exactly what the court and the attorneys asked you to do.
This is one of the most revealing moments of the entire hearing. The judge openly acknowledges that jurors may later discover evidence or information they never heard during trial. That's a reminder that courtroom decisions aren't based on everything that exists. They're based on what the rules of evidence allow a jury to consider. It's a fascinating glimpse into how the justice system balances fairness with fact-finding.
And what the law requires you to do, and that is to consider a matter on which reasonable minds can obviously have differing opinions. Okay, you did exactly what we asked you to do. You're released from the previous restrictions of discussing the case or from viewing social media posts or the video of the trial. And I bet every one of you want to go home and rewatch that right now. You can talk with anyone that you please, but you're under no obligation to talk to anyone whatsoever. I think some of the media have provided you with their contact information rather than besieging you once you leave the courthouse. That is not to say that you may not be met with questions and cameras. It is your decision whether you want to talk to anybody about any aspect of this thing. If you watch any portions of the trial later on or start reading social media posts, you're going to find out that there was some information that the court, and when I say the court, I mean me, that I excluded from the trial of this case because I did not think that it passed the requirements of the rules of evidence. It was my call. I stand behind my decision on that because I thought that's what the law required me to do. But you'll be surprised when you do see that. It has been a distinct honor and a privilege to serve with you, each and every one of you in this case. I'm proud of you, and I wish you the best. You're released. Officer Elam will help you get your electronics and any personal things you have there, and once you get those, you are free to leave. I think, have you already handed out excuses, or you have those? We got those to give you. Maybe.
She's going to give each of
Yeah,
them
Emily
a
can.
badge.
Yeah, okay. Can follow them in and hand out those. Thank you very much for your service. Once again, let's rise for the jury. All rise. Yes, ma'am. Thank you. All right, let's be seated. We're going to give them a few minutes to clear the second floor, give them a head start at it at any rate. Is there anything you know of we need to do before we adjourn?
You know, we need an appearance date.
Yes.
I agree, Judge. And that appearance statement, we would like to serve notice now, we'll file a formal motion. But we would ask the court to consider reinstating the bond in light of this and the amount of time. And I understand that the state is going to, we'll talk about the status of the case when we come back.
We would definitely be opposed to that bond.
I understand. You file your motion, we'll take it up on the next appearance date. Let me see what I've got. I don't have my book. I have the morning of July 2.
Judge, I will be with you on another case. I'll
Okay.
be with you on another case.
Oh, that day?
Yes, sir.
Is it at 9 or at 1 that you have?
It's at 9 o'clock with you, Judge.
Yeah, why don't we set, does that work for the state as well?
That's for appearance only.
Yes. Well, if he files a motion for a bond reduction,
Well, I need to know ahead of time if we're going to have a hearing because I will have a witness from Alabama who will have to be here.
Mr. Taylor, can you,
I'll file a motion tomorrow. I'll file a motion tomorrow.
let's be ready to hear it that day then. He's going to file the motion.
To respond and have my witness here.
I think if he files tomorrow, I think that gives you sufficient time, do you think?
Yes, as long as I get it. Yes, sir.
Okay. I hear you. Okay, July 2, 9 o'clock then.
Thank you.
All right, is there anything else we need to do?
No, Your Honor.
Anything else, Mr. Taylor?
No, Your Honor.
All right, we'll stand adjourned.
You can all go. Tell me that darn thing go to state or camp or whatever. I know what I'm gonna do.